Plus Bill, resumption of the second reading debate.
And I call the Attorney General, and I'll just let you know that at 11 o'clock I will be we'll be moving to question time.
Yeah, I don't think for the assistance of the House, Madam Speaker, I'll make it till 11 o'clock. So probably 6 or 7 minutes at the most. Madam Speaker, I rise to speak on behalf of the government on the Equality Legislation Amendment LGBTIQA Plus Bill 2023. It's true to say, and we all believe, that equality lifts us all and it makes us better and stronger as individuals and as a society. Despite considerable progress that we've made to date, equality still remains, for some people, an unfulfilled ambition. We still live in a world where inequality silences voices and denies people's rights. Madam Speaker, our government knows that we must confront inequality and build inclusive communities that celebrate diversity and foster empathy and social cohesion. This bill makes important changes that brings us closer to equality for those in our LGBTIQA plus community. It rights some of the wrongs. It brings us in line with other jurisdictions in Australia. It removes discrimination and outdated language embedded in some of our legislation, and it strengthens protections for LGBTIQA plus people. Madam Speaker, I stood in this House, in this very place, in March of this year, almost 7 months to the day, and introduced our government's Conversion Practices Ban Bill. On that day, I said that that bill was so much more than just ticking a box on a promise made and a promise delivered. It was a recognition that LGBTQI plus people are not broken, do not need fixing, and do not need saving from their identities. I said then and I'll say again, we love them just the way they are. I'm proud to stand here today on behalf of our government to support this bill that will make further important changes that better recognise, respect and protect members of our LGBTIQA plus community. It is the next step. I'd like to thank the member for Sydney for the way that he's led this landmark piece of legislation in his usual way, and I'm sure that I speak for many ministers and members in this place when I also thank the member for Sydney for the way that he's engaged with our government at each and every stage and with the progression of this bill, respectfully, collaboratively, as always. Principled, pragmatic and patient are descriptors that also come to mind. The member for Sydney has worked painstakingly for over a year now to craft the best possible bill that will, I hope, pass this parliament and that I know will meaningfully make the lives of some New South Wales citizens better, and in a way, therefore, all New South Wales citizens' lives better. I also understand that the member for Sydney will move a number of amendments to his bill that omit some parts and make changes to others, and we're grateful for the member for Sydney's collaborative approach on these amendments. Ultimately, if those anticipated amendments are agreed to, we understand that the bill will therefore make changes to 9 pieces of legislation on our statute books. These changes will remove the requirement that a person undergoes surgery before they can change their sex on their own birth certificate and instead create an administrative process for this to occur, including a pathway for people over 18 and a pathway for people under 18, but only with the consent of their parents and with an avenue through the courts if there are disputes between parents. It will also create a pathway for parentage orders to be made for children born of international commercial surrogacy arrangements when in the best interests of the child with appropriate safeguards. The bill will also provide an example of harassment, which is a form of intimidation under the Crimes, Domestic and Personal Violence Act 2007. There may be outing or threatening to out a person in relation to things like their sexual orientation, variation of sex characteristics, that they live with HIV or that they are or were a sex worker. This has implications for things like the making of apprehended violence orders. We'll also remove an outdated offence that prevents a person engaged in sex work from financially supporting others, such as their children or elderly parents or others, with their earnings. The bill will update outdated language in certain acts. It will amend existing principles to be considered when making decisions about a child or young person's care, to include gender identity and variation of sex characteristics, and the making of a change to minimise duplication in the court system. It will also involve amending the Mental Health Act 2007 to clarify that a person's gender identity and expression of that identity alone do not indicate a mental illness or disorder, and will also clarify that it is an aggravating factor in sentencing before the courts that the crime was motivated by hatred or prejudice for people on the basis of their gender identity or variations in sex characteristics. We expect that some aspects of the Equality Bill will be omitted as a result of amendments to be made by the member for Sydney, principally those being amendments proposed to the Anti-Discrimination Act 1977. As I've said before, such fundamental and significant changes to this Act will best be considered through the New South Wales Law Reform Commission's review into this Act, which is currently underway. Amendments proposed to Section 93Z in the Crimes Act, which is the offence for publicly threatening or inciting violence on the grounds of race, religion, sexual orientation, gender identity or intersex or HIV and AIDS status, will also appropriately be omitted, noting that sex work as a protected attribute is connected to the Law Reform Commission review into the Anti-Discrimination Act 1977. Schedules 5, 7, 9, 15 and 17 of the bill, which propose amendments to a number of acts to provide for alternative arrangements for the search of transgender and intersex people, will also be omitted, which is appropriate as there are operational implications that require further consideration and consultation with impacted agencies. Amendments proposed to the Government Sector Employment Act 2013 will also not proceed as they are not legally necessary, and amendments proposed to the Interpretation Act 1987 are not proceeding at this stage as they will benefit from further careful consideration, particularly in relation to transitional provisions and their potential impact right across the statute book. Other aspects of the bill that we understand will be omitted will continue to be the subject to review or consideration by the New South Wales Government, including further provision of the Summary Offences Act, further provisions of the Summary Offences Act 1988 relating to what is termed in the Act as prostitution, which will be the subject of a review to be conducted by the Department of Communities and Justice. We also understand that the bill will be amended to provide that it commences by proclamation or on 1 July 2025, whichever occurs earlier, which will allow for important arrangements to support implementation of the measures within the bill to take place. I do want to make clear, Madam Speaker, particularly in light of some public commentary today, that this bill does not change anything in relation to how organisations already appropriately regulate people's involvement in sport. It does not change anything in relation to how schools operate. It does not change anything in relation to how correctional centres operate. It does not allow children to make applications without parental support to change their birth certificates. Members of the opposition, I say this again for your benefit, particularly for the benefit of the shadow attorney.
Can I just interrupt just to sorry, Attorney General, can we just enter the room very quietly? This is a very important debate, and if we could just take our seats quietly, not be people behind me talking, just come in, sit down quietly and listen to the Attorney General quietly, please, with respect. Thank you.
The bill does not allow children to make applications without parental support to change their birth certificates, clearly. The bill does not legalise commercial surrogacy or allow parentage orders to be made without appropriate safeguards in place. But, Madam Speaker, what this bill does do is make appropriate updates and improvements to our legislation that strike a balance between supporting our LGBTIQA+ community and respecting the diverse beliefs that exist across our New South Wales community in general. The proposals that will proceed in this bill are overdue, and some of the changes simply bring our state into line with other jurisdictions in Australia, particularly in relation to birth certificates, in relation to which New South Wales is, unfortunately, the last Australian jurisdiction to act. The changes that will progress in this bill will make New South Wales a safer, more gentle and inclusive place. I commend the bill to the House.
Thank you, and very well timed, Attorney General. It being 11